நீ இங்கே இருந்து சார்ஜ் கொடுக்கா அப்படி ஓடு ஓடு ஓடு
Let's see. You do it this one. Do it from here only. Hi Adip, can you hear us?
Good morning, sir.
Good morning.
Hi, good morning. I still can't log in, so
Yes, sir. I am trying. I have to remove some people from the meeting actually.
yeah, no problem.
I'll just
So can you please try again?
Okay, 1 second.
Sir, I have admitted you to the room.
yes, Arjun is joining, so we can start.
Okay. Good morning, dear participants. The Alternative Dispute Resolution Cell, School of Law, Manipal University, Jaipur, is delighted to see you all present here for the day one of the bootcamp on ADR Basics, Introduction to Arbitration and Different Stages in International Arbitration. For our first session, we have Mr. Arjun Doshi and Dr. Mukul Shastri. Mr. Arjun Doshi is currently an in-house counsel at Adani Ports and has vast experience in international arbitration with more than 5 years of experience in arbitration, resolution, etc., of working with top-tier firms like Shardul Amarchand Mangaldas and Co. and Amarchand and Mangaldas and Suresh A. Sroff and Co. He did his LLM from Europa Institute, Saarland University, Saarbrücken, Germany, with specialization in international dispute resolution and foreign trade and investment. Dr. Mukul Shastri is currently General Manager at Adani Group. He is also a General Counsel with 18 years of experience, more than 18 years of experience rather, and adept in business strategy, commercial legal, corporate M&A, IBC processes, PPP infrastructure projects, claim management, litigation management, legal process, both civil and criminal, arbitration including international commercial arbitration, compliance with RBI, SEBI and MCA rules and regulation, trade and competition law, general corporate laws. He is also PhD in trade and competition law, MBA from IIM Ahmedabad, PGPX, company secretary, CIIB, LLM, LLB and DBA. We welcome you, sir. It is an honor to have you with us today. Participants are, please note that your attendance form will be released at the end of the session, by the end of the session, 10 minutes before. And sir, do you want to address the questions in the middle of the session or at the end of the session?
I think it's fine to address the questions in the middle. We would like it to be a little more interactive, so whoever has questions can just jump in and ask.
Yes, so participants who have questions can raise your hands, so we will unmute them accordingly. And so without further ado, let's start with the questions of the workshop. Over to you, sir.
Sure. Thank you very much, Adib, for that very wonderful introduction. So I'll just quickly jump into what I'm going to deal with today. Just one second. What I intend to discuss, and Mukul and I have agreed to try to structure this in such a way that we are able to address the theoretical aspects of arbitration, as well as also based on the experience that we have had, also discuss the practical aspects of arbitration. So what I intend to cover in the next 30 minutes or so is basic concepts of arbitration. What is arbitration in general? What are the advantages of arbitration over litigation? Why is there a shift towards people going into arbitration more often than not? Then, what are the different types of arbitrations, where I intend to discuss ad hoc arbitration versus institutional arbitration, domestic arbitration, and international arbitration. So, those are the different kinds of arbitrations that I intend to discuss. Once I have done that, I want to also discuss the basic elements of an arbitration agreement. And as we go along, you will understand why it's very important to have your arbitration clause and arbitration agreement drafted in a very succinct manner, which identifies the scope and the intent of the parties. Then we will also discuss how not all disputes are arbitrable in nature. So, what are the underlying concepts of what disputes can be referred to arbitration and what disputes cannot be referred to arbitration? In other words, the arbitrability of various disputes. And then I intend to cover the basic three stages, the first three stages of any arbitration process. And then I'll hand over to Mukul sir, who will address the remaining stages of the arbitration and also share his experiences in terms of the arbitrations that he has done in Canada, in various other jurisdictions as well. So let me quickly jump into what is arbitration and what is the intent behind going into arbitration. Now, arbitration is no different than litigation in what it intends to address. So both are dispute resolution mechanisms by which any dispute that arises between the parties can be referred to arbitration. So it's an alternate forum of resolving your disputes. Now, how is it different than court litigation? So when parties have any disputes amongst themselves, let's say a dispute arises out of a commercial contract between the parties, and they would like that dispute to be adjudicated. So they then have to decide where they would like to go for this dispute to be adjudicated. So they could go into arbitration, which would come from the arbitration clause in the agreement. Now, why is there so much about arbitration? What is it about arbitration? It's a private mechanism to resolve disputes between the parties. So there are three arbitrators, or a sole arbitrator, who would be sitting like judges that you see in courts to resolve your disputes. So you have, and those judges and those arbitrators are arbitrators that parties themselves can appoint. So the underlying concept of any arbitration is autonomy of parties. The parties decide who their judges are going to be in arbitration parlance to decide their disputes. They can also decide the procedure, which is unlike in case of litigation. You can't decide the procedure that you would like to adopt in litigation, but parties can decide to choose their own procedure to resolve the disputes in arbitration. Then what does arbitration entail? At the end of the arbitration, the way you have a judgment or a decree delivered by a court, same way in arbitration you have an award which is rendered by the arbitrators, which has the form and effect of a decree itself. So when parties go into arbitration and when arbitrators adjudicate the dispute, they will ultimately come out with what is called an award, which will basically identify the dispute between the parties, the issues at large, what are the submissions made by the parties, and ultimately the ruling. And this award is similar to a decree that you will get in court. You would imagine that why three individuals or an individual outside the court machinery has the power to adjudicate on disputes which are binding on parties, which are also binding on the court, and they can be executed as decree of the court. Where does all of this come from? Where is it that is identified in the statute? So to govern this, you have the Arbitration and Conciliation Act of 1996 in India. That act basically gives legitimacy to arbitration. It also gives legitimacy to the award which is rendered by the arbitral tribunal. Now, I'm going to use a few words here which are very specific to arbitration. So you would have to bear that in mind. And if anybody doesn't understand, then jump in and ask what those nomenclature means. But I'll try to keep it very simple as we can see along. Now you've understood that arbitration is an alternate form of resolving disputes by individuals appointed by the parties themselves. And that appointment by the parties follows from the fact that there exists an arbitration agreement between the two parties. So the two parties to the dispute need to first agree that they would like to resolve this dispute outside the court mechanism, right? So therefore, it is very important to have, first of all, an arbitration agreement. Now, before I go into the essential ingredients of an arbitration clause, I like to discuss what are the advantages. Why would you go into arbitration in the first place over litigation? The first and the fundamental thing about arbitration is the enforceability of the awards that are rendered by the tribunal. Now, India is a party to what is called the New York Convention. And any award which is rendered by an arbitral tribunal or by a tribunal which is governed by the Arbitration and Conciliation Act, any tribunal that renders an award, that award can be enforced wherever the assets of the opposite party are. So let's say Mukul sir and I enter into an agreement. I agree to supply, let's say, 100 tons of phosphoric acid to Mukul sir. There, under the agreement, I have to supply it within 25 days, X, Y, and Z reasons. And then for me to supply, he will pay me a certain amount of consideration. Now, I allegedly failed to supply what I undertook under the agreement. So therefore, he has a cause of action against me. And my contract, the supply contract, provides for an arbitration clause. So it would say that any disputes that arise from this contract will be adjudicated by an arbitral tribunal, and that arbitral tribunal will decide the dispute. So Mukul sir goes into arbitration, and I am made the respondent in that arbitration, and I am someone who is based out of, let's say, England. I have nothing in India whatsoever. Mukul sir is based in India, and he goes into arbitration. Now he gets an award in his favor. So what does that mean? It means that I have failed to perform my contract. So the arbitral tribunal will say that I have breached my contract, and then it will award a certain amount of money to Mukul sir under that contract. Now, by getting that award, Mukul sir will not get the money in his favor, right? He won't immediately be able to get the money. So what will then happen? He will have to go to the courts to get that money from my own assets, right? From where my assets are located, which is generally known as execution or enforcement. In arbitration parlance, that's known as enforcement of the award. Now, with that award, he can go to any jurisdiction in the world where my assets are located. And as long as my assets are located in any part of the world, and if that country is a party to the New York Convention, my award will be easily enforced in that particular jurisdiction. So in this case, an award which is rendered in Mukul sir's favor and against me, he will go to the English courts, give this award to the English courts, and say that I need to get, let's say, 100 rupees from Arjun. So you execute this award and give me that money. And that court, after satisfying itself that that award has been complied with, it has been signed by the arbitrators, and procedural formalities have been followed, will execute that award against me. In other words, that award will convert itself into a money by way of a court judgment. Now the point here is that that award in itself with something which you can take to any jurisdiction. As opposed to that, if you talk about litigation, you will have a decree which will be passed by an Indian court. For it to be recognized in some other jurisdiction, you will have to comply with the laws of the jurisdiction where you want to enforce that decree. And that becomes complicated because you won't have the possibility to follow the rules and regulations of that jurisdiction. So therefore, the fundamental advantage of arbitration is that at the end of that arbitration, the award, the judgment that you will get in your favor, that judgment will be enforceable wherever the assets of the award debtor are located. Award debtor meaning the one who has lost the arbitration and someone who has to pay the monies. That award is enforceable in jurisdictions worldwide, and which is the fundamental advantage of going into arbitration. So that's number one. The second advantage of arbitration is the ability to appoint your own arbitrators. Now, as opposed to that, for example, if you go to any court litigation, you can't choose who your judges are going to be, right? If you go to a high court or if you go to a district court, you can't choose who your judges are going to be. You can't choose who will listen to your case. In arbitration, the biggest advantage of going into arbitration is that you can choose your own arbitrators, i.e., you can choose your own judges. You can decide who that arbitrator is going to be. And that appointment of arbitrators or judges is generally identified under the arbitration clause of the agreement. So it would also identify the appointment process. It will say that one party has to appoint X judge, the other party has to appoint Y judge, and then the two nominated arbitrators will choose the third judge, the presiding judge. So that is the procedure which is given under the arbitration clause itself. And therefore, it is very important that you realize that you have the autonomy as a party to choose your own arbitrators, and that is very important in the context of arbitration. So that is the second biggest advantage. You can choose that judge, that arbitrator. Now, what are those? Why is that an advantage? Sometimes you have disputes which are extremely technical in nature. You have disputes that relate to, let's say, disputes pertaining to construction of highways or construction of oil rig in high seas. If that's the dispute, and then if you're trying to identify whether what was the amount what was the length at which you were supposed to construct, how broad it was supposed to be, all those technical aspects. You cannot expect judges in courts to understand all of that very easily. But if you have a dispute of this nature, you have the possibility to appoint an arbitrator who understands construction disputes, who understands how oil rigs work, how and in what ways you can, that arbitrator will understand what are the technical specifications of doing all of this. So therefore, thank you. So therefore, it's very important that you realize that it's an advantage to have the ability to appoint your arbitrators in case a dispute arises between the parties. So that's the second advantage. The third advantage of having disputes resolved by way of arbitration is that you can choose your own procedure. Now, again, I will take the example of litigation. Why? Because if there's a civil dispute which arises between the parties, the procedure to to run that entire proceeding is identified in the Civil Procedure Code of 1908. Right? Now, that will clearly identify the steps that you are required to undertake in order for your disputes to be adjudicated. But in case of arbitration, you can choose your own procedure. You can choose how the arbitral tribunal is required to listen to that dispute. So let's say you don't have to go to courts. You can do it virtually in current times when you can't physically go for arbitration. Or you could also decide to do it in a closed room, in a hotel room, where you book a conference room. The arbitrator sits there, the parties' lawyers sit there, and the parties also themselves sit there. So therefore, you have the the flexibility to choose your own procedure when it comes to arbitration. That's the third advantage that you have. Are there any questions until now?
Yes, sir. There are three questions.
Yes.
Questions from in our YouTube live stream. Sir, one question is, sir, will you please explain more about mechanism in case of three arbitrators? How can party decide? What would be the criteria?
Right. Okay. That question I will take up when I talk about the arbitration agreements.
Okay, sir. And there is another question in the chat box that if the property of party in default located in a country which is not listed in New York Convention, then what will happen?
Yes, that's a very good question. Then in that, see, as of now, if I remember correctly, there are 176 countries which are parties to the New York Convention. So in most often than not, in most cases, you will have a party whose assets are located in a jurisdiction which is under the New York Convention, and which is the fundamental advantage of going into arbitration. You have assets which are located in a jurisdiction who is a party to the New York Convention. They would have adopted the laws given under the New York Convention and therefore make it easier to enforce that arbitral award. In case a party is not a party to the New York Convention, then in that case you will have to follow the mechanism which is identified in the national laws for enforcement of a foreign award in that particular jurisdiction.
Thank you, sir. And there is another question that.
I think you're on mute. I can't hear you.
Can you hear me now?
Yes.
Yes. So another question is that please explain regarding how an individual practicing advocate can become an arbitrator.
Right. So those are career aspirations that we will take up at the very end when we talk about, if we have time permitted at the end of it, we can discuss how you can develop your career in the field of arbitration. The question about appointment of arbitrators where the clause provides for a 3-member tribunal, I will take that up very shortly. The fourth advantage of arbitration is that it is perceived to be cost effective. And why I say it's cost effective is because you have either institutions, arbitral institutions like SEAC, MCIA, that provide for a schedule of fees that the arbitrators are likely to charge for a certain dispute of a certain value. So let's say your dispute is worth 100 rupees. Then you beforehand know what your financial exposure is going to be in terms of the fees that you will expend to the arbitrators, as well as the fees that you are likely to incur on your lawyers. So that you know beforehand. So it's not that it will come as a surprise later as to what the fees of the proceedings are going to be. It will be decided beforehand, before the proceedings start. In the first procedural conference itself, the arbitral tribunal will decide what its fees are going to be. Then finally, it is also time efficient. Your award from the date on which the tribunal is constituted will be rendered in, let's say, if everything goes very smoothly, will be rendered in a span of 1.5 years to 2 years. And even the Arbitration and Conciliation Act provides for a certain timeline for the arbitrators to render that award. So even there's a statutory recognition or statutory timeline to complete the arbitration process, which you generally don't find in litigation-related matters, because those are governed by specific statutes, and the court takes its own time. So these are a few advantages of arbitration over litigation. Now, moving on to what are the different types of arbitrations. So number one is you have ad hoc arbitration versus institutional arbitration. Now, what is ad hoc arbitration? Ad hoc arbitration is arbitrations where parties decide their own procedure, parties decide who will appoint the arbitrators, and parties themselves decide how and in what ways the arbitration proceedings are going to be conducted. In other words, there is no third party institution that oversees the entire arbitration process. So that is ad hoc arbitration. As opposed to that, you have what is known as an institutional arbitration, where you have a third party institution like Singapore International Arbitration Center, International Chamber of Commerce. Then you will have MCIA, Mumbai Center of International Arbitration. There are a lot of institutions that will oversee the process of how that arbitration runs. Now, if your arbitration is conducted under the auspices of any arbitration rule, institutional rules, that is known as institutional arbitration. The advantage of having institutional arbitration is that you have a third party who is overseeing the entire process of how the arbitration is being conducted. So if, for example, parties are unable to appoint an arbitrator, then the institution will appoint an arbitrator. The institution will chase the arbitrators for the award. The institution will provide conference rooms for its own arbitration process to be conducted. So for hearings also, they provide logistical support. So that is known as institutional arbitration. So these are two kinds or two types of arbitrations. Then you have domestic arbitration and international arbitration. Now, this differentiation of domestic and international comes from the Indian Arbitration and Conciliation Act. Domestic arbitration, the nature of arbitration is determined on the basis of the nationality of the parties involved in the arbitration process. So if you have a domestic arbitration, it means, according to the Arbitration and Conciliation Act of 1996, that two parties to the disputes are both Indian parties. When I say Indian parties, it could be Indian citizens or body corporates registered with ROC in India. Right? So if an entity is incorporated in India, and if the two parties to the disputes are two Indian companies, it would be a domestic arbitration. If there is an arbitration between two Indian citizens, then it is known as domestic arbitration again. As opposed to that, international arbitration would mean that one of the parties to the dispute is from outside of India. So you would have, let's say, a foreign national against an Indian national. That would be international arbitration. If you have one Indian company versus one American company, that would be an international arbitration. So the nature of arbitration, according to the Arbitration and Conciliation Act, is decided on the basis of the nationality of the parties. So that's the distinction between domestic arbitration and international arbitration. Now, I move on to what we defined earlier as the arbitration agreements between the parties. Now, arbitration agreements in simple words would mean that two parties decide to refer the disputes that arise between them to an arbitral tribunal. So therefore, there has to be an agreement between the parties to take the dispute outside the court mechanism and go into arbitration for resolving their disputes. And this arbitration agreements can be formed in two ways. One is before the dispute arises, and the second is when after the dispute arises. If you have an arbitration agreement prior to the dispute, that would be in the form of an arbitration clause in an agreement. I will go back to my example again, where I talked about a dispute between me and Mukul sir. Let's say between me and Mukul sir, there's a supply contract. And in that supply contract, at the time when we enter into that contract, there is no dispute. But we say that if in the future any dispute arises between the parties, then that would be adjudicated by way of an arbitration. That is known as an arbitration clause in the agreement itself. So this is prior to the dispute. Then sometimes what happens is that in my contract, let's say, with Mukul sir, there is no arbitration clause. But after the dispute has arisen between the parties, Mukul sir and I agree that let's not go to the courts, let's go into arbitration. That is known as a submission agreement. So you have pre-dispute, which is an arbitration clause in an agreement, and then you have post-dispute, which is a submission agreement, which parties agree after the dispute has arisen. It is recommended that whenever you enter into a commercial agreement between the parties, and if the parties' intent is to resolve the disputes by way of arbitration, they should upfront agree on an arbitration clause in the underlying contract itself. Because once the dispute arises between the parties don't see eye to eye on anything. And therefore, it is very important that if you want to resolve your disputes earlier, then you get your arbitration clause in the agreement itself. Now, what will that agreement look like? What is it that you have to identify? Number one, on the top, in the very beginning, you identify what is arbitrable. So you will identify any and all disputes, differences that arise between the parties in respect of or out of this agreement would be resolved by way of arbitration. So you identify what is arbitrable. Then the parties consent that this disputes would be adjudicated by arbitration. So the parties have to expressly say that the parties agree to resolve this dispute. The second is the consent of the parties. Then third, you identify in the arbitration clause what are the number of arbitrators that should adjudicate the dispute. So you have to identify, let's say, if it's a small value dispute, then you'll identify that it will be only one arbitrator. But let's say if you're entering into a contract which is worth 1,000 crores, then you would like to have a 3-member tribunal. And that 3-member tribunal, you have to identify what those number of arbitrators are going to be. Then you identify the appointment mechanism. And this is where I will answer the question which was asked to me earlier. If the arbitration provides for a 3-member tribunal, how do you appoint that? So in this case, the arbitration clause will identify that one party will appoint one arbitrator, the other party will appoint second arbitrator, and then the two nominated arbitrators will appoint the third arbitrator. That's generally the mechanism which is identified in the arbitration clause. And that's how a 3-member tribunal is appointed. Now, it is possible that either one of the parties do not appoint an arbitrator, or two nominated arbitrators are not able to agree on who the presiding arbitrator is going to be. Then what do you do in that case? In that case, you go, if it's an ad hoc arbitration, i.e. arbitration which is not conducted under the auspices of any institutional rule, you will have to go to the court to get that appointment, which is governed under Section 11 of the Arbitration and Conciliation Act. If, for example, you have an institutional arbitration, then you go to the institution for making the appointment in case of a default. So let's say if it's a SEAC arbitration, then you will go to SEAC and say that the third one of the parties has not appointed the arbitrator, or the two nominated arbitrators aren't able to appoint the presiding arbitrator, so therefore you appoint the arbitrator now. So that's how the arbitration mechanism works. The fourth important ingredient in your clause would be to identify the seat of the arbitration. Now, what is the seat of the arbitration? The seat means the law that will apply to the arbitration mechanism, the arbitration proceedings. What law will apply to the arbitration proceedings? So therefore, you have to identify the seat of the arbitration, and that seat will determine where you will go for appointment of arbitrators if you have to go to the court. That seat will also determine where you will challenge that arbitral award if you are not happy with the outcome. If you are aggrieved by the award passed by the tribunal, which court do you have to approach for setting aside or challenging that arbitral award? So the seat of the arbitration will determine where you will go to challenge the arbitral award, or where you will go to appoint the arbitrator by the courts. So these are the four essential ingredients that you need to have in an arbitration clause. Now, you would all imagine that all disputes are not arbitrable, right? So, for example, if I commit somebody's murder, I cannot say that take me into arbitration and the tribunal will decide whether I committed the murder or not. So you have to bear in mind that commercial disputes between two parties, in other words, when there are questions about rights in persona, are disputes which are arbitrable in nature. Disputes that are rights in rem, disputes pertaining to rights in rem. In other words, criminal law disputes are disputes against the public. So therefore, those disputes are not arbitrable in nature. So the fundamental thing that you have to bear in mind is that when there are disputes pertaining to rights in persona, those disputes are arbitrable in nature. Disputes that pertain to rights in rem, those are not arbitrable in nature. The second category of disputes, which are not arbitrable in nature, are disputes where the subject matter is taken care of by a statute in itself. So let's say that you have a dispute relating to Trust Act, Indian Trust Act, disputes arising between the trustee and beneficiary, or disputes arising between the author of the trust and the beneficiary. Those disputes are again not arbitrable in nature. Why? Because those disputes are specifically covered by a statute, which is the Indian Trust Act. That statute provides for where you have to go in case the dispute arises between the parties, what are the rights and remedies available, and therefore any dispute, the subject matter of which is covered by a specific statute, will not be arbitrable again. The underlying rationale for that is that parties have, when there is an act which determines or which takes into account everything related to a particular subject, and if it also provides for the forum or the jurisdiction of the courts, it means that there is an implied exclusion of the disputes to be adjudicated by an arbitral tribunal. So if the Trust Act says that this dispute has to be adjudicated by a court, then in other words, the arbitral tribunal's jurisdiction is impliedly excluded. So two categories of disputes that are not arbitrable in nature: disputes pertaining to rights in rem, and disputes which are otherwise covered by a statute in itself. So those are the two categories of disputes which will not be arbitrable. Uh, Moving on to the different stages of arbitration, and I will now take 5 minutes to answer this. So whenever a dispute arises between me and Mukul sir, let's say the same example, what is the first step that you will take? The first step, if you want to initiate the dispute against me, would be to issue a notice of arbitration. The notice of arbitration is the first step to initiating the arbitration process. So if Mukul sir has a dispute against me, and if he wants to initiate the arbitration process, then in that case, he will issue a notice of arbitration. What will that notice of arbitration identify? That notice of arbitration will identify who the parties are, who the lawyers are. So you will have to give the coordinates of the parties for service. You'll also have to give the coordinates of the lawyers of the respective parties. Then you will identify your claims in a very brief manner. Then you will identify what the arbitration clause provides for, and then you will make the appointment of the arbitrator. So let's say in the underlying contract, you have a 3-member tribunal, then I will appoint my arbitrator in the notice of arbitration itself. And that is known as the notice of arbitration. So Mukul sir will issue a notice of arbitration. The next stage would be for me to respond to that notice of arbitration. So I will again identify my lawyers, parties, then refute to the claims that the other side is making. So whatever Mukul sir has said, I will deny those. I will put my claims in a very brief manner. And then I will come to the arbitration clause. And wherever there is an arbitration clause, if it's a 3-member tribunal, I, respondent, gets the opportunity to appoint the third arbitrator. The second arbitrator. So I will make the appointment of the second arbitrator. So now you have notice of arbitration, that in which there is appointment of the first arbitrator. Then there is a response to notice of arbitration in which I have appointed my own arbitrator. So you now have 2 arbitrators. The next stage is to constitute the tribunal. And the tribunal will only be constituted when you have 3 members on that arbitral tribunal. So the 2 nominated arbitrators, the one appointed by Mukul sir, the other one appointed by me, will appoint the presiding arbitrator, and that's when the arbitral tribunal will be constituted. In case three members are not appointed, then depending on the nature of the arbitration, you could either go to the court if it's ad hoc arbitration, or you could go to the institution if it's institutional arbitration to constitute the arbitral tribunal. And that's where you will have constitution of the tribunal. Now, these are the first three stages of arbitration, and I will now hand over to Mukul sir to carry this forward. And before I do that, if there are any questions for me, please feel free to ask now.
Yes, sir. I'll unmute the person who wants to ask the question.
Sure.
Bhagesh, you can ask your question.
Good morning, sir. Sir,
Yes,
I
Bhagesh.
have, yes, sir. I have one doubt that what can be done if one party ignores the arbitration agreement and commence court proceedings? Then what steps can be done?
A great question. Just to simplify what Bhagesh has said, there is an arbitration clause in the contract. One of the party who wants to raise the dispute ignores that arbitration clause and goes to court. That's the simple point. Now, what happens in this case? In this case, if the other party who is being taken to the court, if he raises that objection before the court, that this dispute which is submitted by the party is governed by an arbitration clause. Look at this arbitration clause and you will see that this dispute has to be adjudicated by the arbitral tribunal. If that happens, then the court has to refer the parties to arbitration. And this is generally known as a Section 8 application. This is covered by Section 8 of the Indian Arbitration and Conciliation Act. It provides for parties to be referred to arbitration if the underlying contract provides for an arbitration clause.
So our next question is submission agreement. So it is to be in what form? Like it can be in written form or it can be in oral form?
No, it has to be in written form. So every arbitration clause or every arbitration agreement has to be in written form. So even the submission agreement has to be in written form. When dispute arises between the parties agree to resolve their disputes by way of arbitration.
There is another question. Someone has asked, the Indian Contract Act governs the subject matter related to commercial agreements. So
Right.
how does it provide a remedy via arbitration?
So the Indian Contract Act provides for the rights and obligations that arise between the parties, right? So it basically provides for when the contract would have been concluded, what is the mechanism by the contract will have to be concluded. One second. I need to plug in my charger. Yes. So the Indian Contract Act basically provides for, it does not provide for any remedial measures, right? When a statute provides for remedial measures, like let's say Indian Trust Act, it provides for where the parties need to go if a dispute arises. What are the rights of the trustee? What are the rights of the beneficiary? Those sort of things are not covered under the Indian Contract Act. The Indian Contract Act only provides for when an agreement is concluded, when can the agreement be avoided, when it is void ab initio. So it's the governing law. It's not a statute that provides for rights and remedies between the parties.
Okay, sir. Sir, there's another question. When there is one party from another country, can you choose their local laws of that country?
Yes, you can. See, you have to bear in mind that arbitration is all about agreement between the parties. So parties are free to choose what they would like to choose.
Okay. Sir, there's another question coming up. Like someone has asked, is there anything like contempt of court in case of failure of the arbitral award?
No, there is nothing like that.
Okay, sir.
Another participant wants to ask a question. I'm unmuting him. You can ask the question.
Good morning, sir.
Yes, Mehta.
So I had a question. In case of international arbitration, so one party is outside India, right? So do they mutually come to an agreement that okay, this state's laws will be followed, or which language?
Right.
Is it mutually decided, or is there any
Yes.
set of mutual laws which all the parties are bound to follow?
No, no. They parties. This is party specific. The parties decide themselves.
So there is another question. Uh, what are the eligibilities to become an arbitrator?
See, again, as I said, this is all agreement between the parties. So if I want to appoint someone as an arbitrator, I am free to do that. I am free to choose who my arbitrator is going to be. It could be anyone who is not related to me, who shouldn't be someone who has an interest in the subject matter. I cannot appoint my dad as the arbitrator because he has a direct interest in what the outcome of that arbitration is going to be. So an independent, neutral arbitrator, whoever that person is.
Sir, someone is asked, what if the arbitral award is disobeyed? Is there anything like the contempt of court or something?
No, there's no contempt of court. An arbitral award is like a decree. So if it is not challenged, it is converted into a decree of the court, and then you can go and execute that decree.
Sir, someone is
Um,
asking, can you repeat the third point of arbitrator? Like third arbitrator appointed by whom? That point.
So two arbitrators who are appointed by the parties gets to choose who to appoint the third arbitrator.
Okay, sir.
so there is another participant who wants to ask the question.
Yes.
You can ask your question.
Yeah, thank you, sir. Arbitration, I mean, the parties are free to choose the arbitrators, right? But
Right.
when one party chooses arbitrator, the other party can object, right? They can raise some kind of objections. Yeah, in what circumstances such objections can be raised? You can give some examples, right?
Right. So the example that you get, so the underlying rationale of any appointment of arbitrator is that that arbitrator has to be independent, impartial, and neutral. Right. So where there raises questions about the independence of the arbitrator, neutrality of the arbitrator, in those circumstances you could raise an objection. So let's say that there is an arbitrator which is appointed, and that arbitrator has some direct interest in the subject matter of the dispute. Now, that arbitrator would be interested in the outcome of that particular dispute. Now, that arbitrator cannot be appointed. Why? Because he is not independent, he is not neutral, he is not impartial. And therefore, objections with respect to appointment of the arbitrators are generally based on the independence and neutrality of the arbitrator.
Thank you, sir. Thank you.
So there are more participants to ask questions. This will be the last question that will be asked.
Right.
You can ask your question.
Hi.
Yes. Hi, Kamya. Hi, Kamya, I think you are on mute.
The host kept muting myself. So my question was basically, is there any circumstances in which the arbitral tribunal can be consist of, like for example, an even number? In this case,
No,
it
no,
never under
no, never.
none circumstances. Okay.
No, never, never. Right. Uh, so, if are there any further questions?
Yes, there's another question.
So whoever has raised their hands, let's just finish those off, and then I'll give it to Mukul sir, and then if time permits, we'll take it at the end then.
Okay, sir.
Sir, I have one more doubt. Sir,
Yes.
if an party made a default or disobeys the order passed by an arbitration, sir, what can be done?
So as I said, if you have an arbitral tribunal that passes an award in Mukul sir's favor and against me, so the tribunal will say that Arjun has to pay 100 rupees to Mukul sir. I don't obey that order. right? So what happens in that case? It means that I am not voluntarily paying 100 rupees under that award. So Mukul sir has to take that award to where my assets are located to get that award executed. So there is not, it is not that there is disobedience of an arbitral award. I am not complying, or I am not voluntarily paying under that award, and therefore whoever is the award creditor has the option to execute that award against the award debtor.
So there is another question.
Yes, go ahead. Last two questions, and that's it.
Yes, sir. Yes, you can ask a question.
Suraj, do you want to ask? I can see your hand
Yes,
raised.
I believe we have discussed, we said about it is less expensive than court proceedings, this
Yes.
arbitration. Yes, so what will be the cost of arbitration? Will it be discussed later, or is this that?
No, the cost of the arbitration is generally dependent. So there are two ways of deciding the cost of the arbitration, generally speaking. One, according to the Indian Arbitration and Conciliation Act, you have what is known as Schedule 4. That Schedule 4 provides for the fees of the arbitrators depending on the quantum of the dispute. So let's say if the dispute is between 10 lakhs to 15 lakhs, then it identifies the range of fees that the arbitral tribunal can charge. So you know beforehand what your financial exposure in terms of tribunal fees are going to be by just simply looking at that schedule. Right, Subradi, and this is the last question.
Good morning, sir. Sir, I
Yes.
would like to ask, so in case, like, if I'm not happy with the award given by the arbitration or the tribunal, so are there any appellate jurisdiction to it?
Yes. So if you're not, if you, and which is what I said. So if you're not satisfied with the award which is passed by the arbitral tribunal, then you can challenge that arbitral award at the seat of the arbitration. So let's say your arbitration clause provides for India as the seat of the arbitration, then an award with which you are not satisfied, that award will be challenged under Indian Arbitration and Conciliation Act before an Indian court. And the provision for that is Section 34 of the Arbitration and Conciliation Act. Right. So this was very good, very engaging. Thank you very much for the opportunity. I will now hand it over to Mukul sir.
So wonderful session, and thanks Arjun for such a great insight. And thanks to the Manipal University and all of you, all the organizers. An absolute pleasure to be amongst you all. So it's an interesting session, and Arjun has really laid the base foundation as what arbitration is, and what are the ingredients of arbitration agreement, what is an arbitration clause, and why arbitration is better than a plain, simple litigation when you go to court. So now we have to discuss about the stages of arbitration, that what happens actually once the tribunal is constituted, and then what is the procedure that generally is followed in these tribunals. But before coming to that, I will just like to share a very interesting anecdote, because we are all discussing about arbitrability, and I saw some kind of chat question saying that Indian Contract Act provides for contractual breach and disputes. So why not, how can contract disputes be under arbitration, and how are they different? So I'll share my anecdote and then I'll answer a few of those questions. So what happened when I was in RPG group? So before Adani, I was with RPG group, which is into CH tires and KEC and power transmission and so on. So one of my first assignment when I joined them was that there was a matter in Algeria, in Algiers city, whereby there was a dispute between our vendor there and us. And we have to fight a claim against that vendor because faulty material was supplied to us. And therefore, we filed an arbitration. It was an ICC arbitration, Paris International Chambers of Commerce arbitration. And we went for arbitration and gave our arbitration notice, as Arjun said. Interestingly, when we filed that arbitration notice, the vendor was a public sector undertaking. It was a PSU under the Algeria. So what they said is, they said that since we are a government entity, and as per the Algerian laws, those government entities, when they are acting as a sovereign nation or sovereign entities, you cannot file an arbitration against them. You have to only go to the court of law, and you have to go to Algiers court if you want to have any dispute or if you want to get any claim from them. And that was a great learning for us. So despite there being an arbitration clause, despite it being a commercial agreement, but because a particular law of that country prohibits that this particular thing is not arbitrable, a claim against PSU is not arbitrable, we could not get the full advantage of arbitration. Ultimately, we have to go to the court of law and then go ahead with the court process. So there was a great learning for us in that experience. They're twofold. One is that though we have arbitration now across jurisdiction, as Arjun said, there are so many countries which are now party to the New York Convention, and therefore this arbitration is very, very famous amongst various countries. But then again, the idea is that there are certain countries which have their own interesting laws which can make it a bit interesting. So like in Algeria, we face this issue. So therefore, you have to be very much aware about what you call about this local law also when there's an international arbitration. Now coming to answer a few questions, and then I'll just continue with the stages of arbitration. Like if Indian Contract Act also provides for the breach of remedy, then why arbitration for that? So the basic answer, simple answer to that is, see, there are only two things which are arbitrable, and rest everything is not arbitrable. You can simply say that. One is anything which is a commercial dispute, and second thing is it can be through a contract or otherwise. Now, when I say commercial nature dispute, it means if I and you have entered into an agreement, and by giving monetary relief to a party, that remedy can be attained to, then only this is an arbitrable matter. If by giving a monetary remedy, something is not satisfied, then that cannot be arbitrable. That is what is the precise, what you call, distinction between what is arbitrable and what may not be arbitrable. So the idea is whether monetary relief can remedy a situation. So for example, if there's a husband and wife and they want a divorce, by awarding a monetary, what you call, award, that alone may not be satisfied because it will require something more than that actually. You have to annul a particular degree. So that is why that is not an arbitrable dispute. And likewise for trust and for certain other things. But other than that, whether it is contractual or otherwise, whether it's tortious or whether it's a contract, if something is in a position to be remedied by awarding money, then that particular thing is an arbitrable dispute. So this is what a thumb rule is. Okay, and therefore all these contracts and all those things, they are arbitrable. Well, ultimately what you claim is you claim a breach, you claim a remedy, monetary remedy for that breach. You're not claiming any specific performance. If you are claiming any specific performance, then it becomes a very tricky issue. Well, then it may or may not be arbitrable depending upon what kind of specific performance it is. If it's only a handing over of a car, handing over a house, it may become arbitrable. But if it is something beyond that, it may not be arbitrable. So that's what the thumb rule is. So if money is in a position to answer your remedy or what you call remedy you, then it is arbitrable. Now let's come to, so as Arjun said that there is a constitutional tribunal, or tribunal is constituted. And we have suddenly jumped to the award given by the tribunal. But the question is, how is this tribunal going to come to a conclusion for that award? So let's just discuss that also in brief. And then we'll discuss two international arbitrations and Indian arbitrations and the practical discourse to it, that how arbitration actually happens in India and abroad, in institutional arbitration, say SIAC, etc., and outside India, ad hoc arbitration. I'll share you practical insights with the arbitration that I have carried into in Canada, in Singapore, in Algeria, as I said, and what difficulties we faced. Now coming, and then we'll take some career aspiration question also, that what kind of different careers can also be there. Now coming to the stages of arbitration. So once the arbitration notice is given, so there are two persons, A and B, who have a dispute. A has given an arbitration notice to B that, okay, now I want to constitute, now it's a dispute and I want to constitute an arbitration tribunal. We have an arbitration clause. Now, once that notice goes, this person is also going to tell you that this is my arbitrator. So A says that Mr. X will be my arbitrator. Now B has to decide that, okay, if Mr. X is A's arbitrator, and if it's a 3-member tribunal, B will have its own arbitrator Y, and then X and Y will decide Z as the presiding arbitrator. Now, once this arbitral tribunal is constituted, once these 3 arbitrators are decided, and they are now holding the arbitration, the first thing that they do is they do a procedural hearing. And in that, they lay down the foundation that what is going to happen for this arbitration tribunal to fructify. So what will be the process? What is the procedure that they have to take or they have to follow to achieve the award stage? So it is decided by the tribunal itself. So both these parties, A and B, along with this tribunal, they will appear. A can have his own counsel, B can have his own counsel. And all of these will then decide about the procedural formalities that this tribunal has to undergo. So what is the typical kind of an arbitral procedure? It is, first of all, the time is given to the claimant, the one who is claiming something against the other party, to file a statement of claim. That, okay, whatever is you think you are entitled for and why you are entitled for those things, you bring out in a statement of claim that, okay, A is now to say that A and B, we have a contract and B has committed a breach of contract and therefore I should get this much money from B. So all those things as to what he wants to get from B and why he wants to get it from B, that he has to put it in a statement of claim. Now, once the statement of claim has been filed, the second step is for the defendant or the person against whom the claimant has raised these claims to file a statement of defense justifying that why the claimant is not entitled for what he is claiming for. So what are the reasons why he should not get these things? What is the logic? So rebutting whatever the statement of claim is a statement of defense saying that he is not entitled to these things because of these reasons. And then he can also have a counter claim. He can say that, okay, he might have filed a claim of 100 rupees against me, but in fact, I am not entitled or liable to pay any money to him. He is not entitled for that 100 rupees. On the contrary, I should get 150 rupees from him or 50 rupees from him. So he can file a counter claim that, okay, and then the logic that is to why this counter claim, what are the reasons why he should get this counter claim. So this is what the defendant has to then file. So the first stage was statement of claim has been filed by the claimant. Then the second stage is the statement of defense has been filed by the defendant, and defendant also can have a counter claim. If it is a counter claim, again the claimant get a chance to counter that counter claim, to file a rejoinder or to find a reply to that counter claim, that why this counter claim he is not entitled to get. So this is what the documentation is. So now before the tribunal, there is a statement of claim, whereby it is all the claimants, what claimant is claiming is there. There is a statement of defense as to what the defendant is saying, why the claimant is not entitled for the claim, and a counter claim, if any. And then the reply to that counter claim also is there. So these documentations are there before the tribunal. Now what happens next? Now see, in all these documents, either there can be certain annexures, there's certain more documents which have been relied upon to justify the statement of claim or to justify the statement of defense. There may be some more documents. So the next stage comes is whereby there's a stage called as admission of documents or admission or denial of documents. So the parties, these two parties, they can either agree to that, yes, these documents, they exist. Suppose statement of claim has 20 emails attached in that. Let's see, because of these emails, he should pay me this money. So now the defendant can say that these 20 emails that he has put in, these 20 emails are genuine. Definitely these emails have taken place. Or he can say that there's one of such emails or few of such emails are all fake emails, that these documents never existed. So he can deny the document per se on which the claimant is relying upon. Likewise, in the statement of defense, whatever documents have been relied upon by the defendant, the claimant can say that these documents, they may exist or they may not exist. So now the tribunal has statement of claim, statement of defense, and those kind of admission of document that, okay, these documents are admitted documents. This means the tribunal doesn't have to decide whether these documents are genuine or not, because both the parties have admitted those documents. But there will be few on which there are denials, that these documents are denied. So in those cases where certain documents are denied, then it is for the tribunal to decide that whether those documents, they do exist or they do not exist. So the tribunal then have a hearing whereby it will see that these documents which either party is claiming to be genuine and other party is saying that these documents do not exist, or their admissibility per se is questionable. See, there can be three grounds of objection to a document. One is the existence of the document per se, that this email, this letter never ever took place. Second is about the relevancy, that this document may have taken place, but it is not relevant to the list which is right now between the parties. It is not relevant to the dispute. And third can be the admissibility per se. For example, any communication between a lawyer and his client is a privileged communication. So in that, whatever has been said cannot be brought before a court of law or before an arbitral tribunal, because that admissibility per se is questioned as a privileged document. So on those grounds, it can be questioned. And then it is for the tribunal to decide whether the existence, after hearing the parties, whether the existence, the relevancy, or the admissibility of the document is to be allowed or not to be allowed. So then the tribunal decide that yes, the document is available, is there, is admissible, and it is relevant. Okay, so then that is the next stage of the document. Then comes the next stage is regarding discoveries and interrogatories. So you might have those who have studied CPC might have seen about interrogatories and discoveries. See, the statement of claim will only have those documents in which the claimant is relying. The statement of defense, the defendant will only rely on those documents which defendant wants to rely upon. Now, suppose the claimant thinks that there are certain documents only in the possession of the defendant which are relevant to strengthen his case. And likewise, defendant feels that there are certain documents which are available with the claimant which can strengthen his case. In that case, they can come with interrogatories or discovery of document, whereby the claimant can say that please, and can ask the tribunal to please direct the defendant to furnish this document also, which are in his possession, which I want to discover. And likewise, defendant can also ask the claimant, the tribunal to ask the claimant to give certain documents which are in the possession of claimant alone and not in the possession of the defendant. So this is the next stage, where then the tribunal again has to decide on the same basis, on existence, on relevancy and admissibility, whether those documents which the other party is alleging the other party has, either they are really in existence, and if they are in existence, are they relevant? If they're relevant, are they admissible for this particular dispute? So that is the next stage. So now what is there? There's a statement of claim, there's a statement of defense. Various documents have been admitted, which are to be relied upon by the tribunal, and now additional documents through discovery and interrogatories also are there. So therefore, we have a whole list of documents available before the tribunal on which they can decide this matter. Other than this, then there can be so documents may be there, but then there can be certain evidences which may be required by either parties to strengthen their cases. And then they can say that other than these documentary things which are there before the tribunal, I would like to present before you the evidences of witnesses, that this is my expert witness, if it's a complex technical thing, to explain the technicalities of a particular thing, or they can be fact witnesses to explain certain facts, that this is how it happened or what it transpired. So these witnesses then will have their affidavit filed before the tribunal. They will write whatever they want to write, whatever they want to contribute, and that will be served to the tribunal and to the other party. So statement of claim is there, and claimant has additional documents and certain witnesses, fact witnesses and expert witnesses, which the claimant has produced. Likewise, statement of defense, certain discoveries, certain documents which defendant want to rely upon, and the statement by the witnesses that defendant want to put for, or the expert that defendant wants to put for this matter. All these things are there before the tribunal. All these documents are there before the tribunal. Then the stage comes whereby either party can cross-examine the other party's witnesses. So if the claimant thinks the defendant's witnesses which he is relying upon, they are not telling the true picture before the tribunal, then he can cross them. And they will try to elicit the information which is not there before the tribunal, which this witness has brought in. He has only brought in half knowledge. So he can try to cross and try to get the full knowledge before the tribunal. Likewise, defendant also can cross the witnesses of the claimant. So this is what is there before the tribunal: the statement of claim, the statement of defense, the documents which the claimant want to rely upon, the document which the defendant want to rely upon. Those documents are admitted now before the tribunal, the discoveries and the interrogatories, and the fact witnesses, the expert witnesses of both the parties after their cross. Now, when the tribunal has all these documents, then the tribunal will have a final hearing whereby both the claimant and defendant can put their arguments before the tribunal based on this evidence only, which is now before the tribunal. They cannot go for any extraneous evidence, because now tribunal has a four corner that this is what is the fact before the tribunal. Now these two parties can then build their case, can argue based on these facts and whatever law they want to raise before the tribunal, and on that basis they can conclude their argument. So after hearing both the parties, after seeing the facts which are there before the tribunal and the law which the parties have argued, the tribunal will then give a final award, which has to be a reasoned award, a reasoned judgment a final judgment by the tribunal. So that which is called as an award in arbitration parlance. So this final award is where the tribunal will state that this is what the claimant has asked for, this is what the defendant has countered, and therefore this is the witnesses before me, and this is the law point before me, and therefore I award this claimant this much money, or I dismiss this entire claim. So this is how the procedure takes place in a typical arbitration. Now, which is and it is agnostic to whether it's an international arbitration or a domestic arbitration, whether it is an institutional arbitration or ad hoc arbitration. This procedure generally is the same for across all the arbitrations. Okay. So this is how the entire arbitration takes place. Now I'll give you a few anecdotes, some real examples of how the arbitration has taken place in real life. Indian examples and some foreign examples. But before that, any specific question that you have? Anyone, anything till now? Then we go to specific examples. Some practical examples we'll touch upon. Any questions?
So there is one question that if the claimant has set out his claims in SOC, then why counterclaim needs to be filed if the respondent can make counterclaims in his SOD?
No, counterclaim is what defendant is claiming. So in statement of claim is the claim by the claimant. So claimant is saying, so suppose there's a fight between, like Arjun example, between Mukul and Arjun. So it is Mukul who is saying that Arjun has to pay me 100 rupees. That is a statement of claim. But Arjun says that no, Mukul has no right to get 100 rupees from me. On the contrary, I should get 20 rupees from him. That is a counterclaim. So counterclaim is a claim by defendant against the claimant. So that has to be raised in the statement of defense by a defendant.
Thank you, sir. Sir, one participant wants to ask a question.
Yeah, please. I can see Saktivel has raised his hand.
Yes, sir. Thank you. Sir, this each party, they can propose witnesses for to support their case. Suppose one party, if he want to interrogate the other party witnesses, so that interrogations will be done in front of the tribunal, right?
Correct. So
okay. Yes, please.
So there are multiple ways. So one is generally there's a tribunal, and you can cross, and there's a tribunal, and tribunal decides upon what kind of questions you can ask. And if some party wants to take an objection, the tribunal can decide on those objections. There is one way of doing the cross. Sometimes what happens is parties can decide that okay, you can. So this is what typically cross is before the tribunal. But sometimes the parties may decide that okay, I will do a cross, and if the tribunal is not there, doesn't matter. I will just transcribe the entire thing. I'll keep on asking questions, and whatever the answers are there, and the objection of the party, everything will be written as a transcript, and then later the transcript can be filed before the tribunal, and we can argue based on those transcripts also.
Okay.
But typically, generally, it is before the tribunal.
Thank you. Thank you.
So there is another question. Can tribunal punish either party for not complying with its orders?
No, so there's a similar question of how an award can be executed. So idea is same only that if a party is, so suppose tribunal has given an order in favor of say Mukul in Arjun's example, and now Arjun is not complying with that order, Mukul has to then go to a court of law and get it executed. So in court of law, when Mukul will go, the court will then say, okay, there's an arbitration award in favor of Mukul. We'll simply go and find out what properties are there of Arjun, and will attach those properties and get that money to Mukul. So as I said, the arbitrability, the main question, the thumb rule is only those things which can be satisfied through money are arbitrable. Okay. So once an arbitration award is there, the money is satisfied through the court process. So you go to court will attach the property, will sell the property and give you the money which you are entitled to, and then the property, whatever remaining is there, will go back to the party whose property belongs to. So another example, court will execute, attach Arjun's property, give me 100 rupees, and then if the property is worth 1,000 rupees, give 900 rupees back to Arjun. So this is how it will be satisfied.
Okay.
So one of the participants wants to ask.
Bhagesh.
Yes. You can ask a question, Bhagesh.
Good afternoon, sir. Sir, I have doubt if I am unhappy with the arbitrator's decision. Is there any appeal process in it?
Yes, there are. So there are two types of provisions that are there. Section 34. So with the final award, whichever is the final award which is there, if you are not satisfied, then Section 34 of Indian Arbitration Act, in Arbitration Conciliation Act, it gives you the grounds in which you can challenge the award. You can say that I'm not satisfied because of 1, 2, 3 reasons, but then the reason has to be like the arbitrator was prejudiced, or the kind of law that arbitrator has applied is not what in India we follow, or the award is against the public policy, and otherwise, or something which is arbitrator has gone beyond the 4 corners of the arbitration agreement, and likewise actually. So you definitely can challenge it under Section 34. And then second is Section 37, whereby again you can challenge it further. So there are possibilities of challenging an arbitration award.
Okay, thank you so much, sir.
Anyone else?
Yes, sir. There is a question in the chat. Is there a possibility of non-cooperation by witness in the course of evidence procedure?
There are possibilities. A witness may or may not cooperate, but then if the witness doesn't cooperate, then see, idea is very simple. It will be an adverse inference against that witness, against that party. So suppose in our example, like Mukul and Arjun's example, if I have to rely upon, say, 2 witnesses, witness A and witness B, to strengthen my case. Now, if my witness A is not cooperating, if he's not allowing himself to be crossed, he's not cooperating at all, then it will be an adverse inference. Witness A's, whatever testimony he has given, will not be taken on record. And therefore, I will suffer as a claimant because my witness, whatever he could have brought in before the tribunal, that will not be taken on the record. So I will suffer. So that's how so there will be an adverse inference against them. Okay.
Okay, sir. So there's another one coming.
What stage new evidences can be given? Someone asking. So as very interestingly, as arbitration is all what parties decide and what parties have. What you call the 2 parties can decide as to what kind of procedure they want to adopt. So as per Section 19 of Indian Arbitration Act, CPC per se is not applicable. Therefore, the parties can decide, and the tribunal can then decide upon the procedure itself. The tribunal also has the right to decide upon the procedure that it's going to follow. So generally, what happens is whenever it is you have got any evidence which is in your possession, you should bring it. So, like an example, in statement of claim, if you are aware about something, you should brought in your statement of claim itself. Likewise, if the referent is aware, you should bring in SOD itself. But if there are new facts which you came to know later, then you can give the evidence of that later also, provided the tribunal allows. But if something which you are aware of and you have not brought it in the first instance, then if you want to bring it later, other party may object to it, and then the tribunal may decide that no, this evidence now which you are bringing, which you could have brought at the stage earlier, then tribunal may disallow also that evidence based on because you have not brought it at the right stage. There is a possibility of that not being allowed. So therefore, whatever information you have, whatever documents you want to place your reliance on for a particular arbitration, you should bring in at the first instant itself, the first opportunity.
Sir, there is one question from YouTube. Saundarya Minakshi asked, after me obeying the arbitral award, my PSU, namely IOC, failed its part. But this case happened in year 2010. Can it be revoked now, or is there any limitation of time?
So if I can understand the question correctly, so in 2010 there's an award passed in favor of someone against a PSU, and now they want to get that award enforced in 2021. Is that the question? So the idea is it will all depend upon what is the subject matter. Generally, limitation of execution of any award is 3 years until it relates to some immovable property, then it is 12 years. So now it has gone beyond the scope of limitation. So it will be difficult unless the person can show that there was a fraud and therefore the arbitration award was told only now. He can show that why there's delay of 11 years, 12 years. If there's some very genuine ground, then the limitation can be relaxed. Otherwise, the limitation is expired for execution of this particular award.
Okay, sir. So there's another question. Why is TPF considered violative of public policy?
Why is I didn't get it question.
Why is TPF considered violative of public policy?
So third-party funding, if I say the
Yes,
TPF means.
Yes, I think so.
No, so see, third-party funding is a concept called as maintenance and temporary. Okay. So now, if you see under Indian law, so now on the contrary, this litigation funding is increasing also. But if you see Indian law, idea is that if I have a dispute against you, if A has a case against B, A has to fight it out actually against B, and A cannot sell his right to claim to third party. Okay. because there is maintenance and champerty, but that is again a process for the court laws, for civil procedures and for the court procedure. For arbitrations per se, in India also now this trend has picked up that if you have a claim, suppose if company A has a claim against company B, company A can sell this claim, whatever it has against company B, to a third party, and third party can pursue this claim against the company B, and whatever award the company gets, the third party can keep it and can pay certain portion to company A, who was the initial claimant in the first place. So for arbitration, and especially for international arbitration, this trend is really now picking up, which is there, and it is not banned in law. The maintenance champerty, which is per se not right now available in India, is for the court processes, which are prohibitive because of the Indian laws. That may change in some time.
Okay, sir. Sir, there is another question. Like, one party is not interested with the arbitrator because at time resolve the dispute he shows some partiality. Can the party boycott that particular arbitration or that arbitrator?
So what the question is that if I do not like an arbitrator in the first place, what are the remedies that I have against that arbitrator?
Yes.
So see, my arbitrator I will nominate. If the three-party arbitrator, my arbitrator I will nominate, other party's arbitrator, other party will nominate. So I cannot have any objection to that arbitrator. But then these two, my arbitrator and the other party's arbitrator, they will appoint a presiding arbitrator. So if they can come to a consensus, then it's fine. If they cannot come to a consensus, then depending upon what is, if it's an institutional arbitration, you'll go to that institution and then that institution will appoint. Otherwise, you'll have to go to court of law and then the court will appoint an arbitrator, the third arbitrator. Okay.
Okay. Okay.
Sir, there is another question that when proceedings before an arbitrator is not a judicial proceeding as per Evidence Act, then why the award is equal to a decree of court?
No, so there are two different concepts actually. See, first of all, the arbitral award. See, otherwise, what is the sanctity? See, why arbitration has come, as what Arjun has initially explained. See, the idea is that why arbitration? Why the first arbitration? Why not court cases? Because the moment, first of all, the court cases can be very lengthy. Number two, the court cases are I can be before a judge who may not be an expert in that particular technical field in which the arbitration is. And the third is enforceability. Indian court orders may be enforced only in India. I have to go outside. I have to follow again a lengthy court procedure. And therefore, this arbitration way back in 1940. Since 1940, they have an arbitration act, and this has been constantly developed for the last 60, 70 years. The idea is that let me have an arbitral award, and this will be much more easier and convenient for me that a third party, an impartial person has decided something, and I simply go to a court and get it enforced. So going to a court and getting it enforced is a different ball game, and so that is what the entire purpose of arbitration is. That somewhere it's an alternate dispute resolution. That therefore you are not enjoined to go to court of law and go to a very protracted legal battle and get some award or get some order from that court and get it enforced. So to cut short the initial or the lengthy process of going to court of law and getting a judgment, I have made it cut short before an arbitrator in a very simple process. Process also is to be determined by the parties and by the arbitrator itself, and get an award which is by an impartial third party. And then I'm going to court of law and getting it enforced, because now both the parties have agreed to it. So therefore, the entire purpose of having an arbitral award or arbitration is different, to cut short that initial process of court, because that's a lengthy process. Ultimately, I have to go to court of law and get it enforced, because enforcement only happen by a court, because arbitrators, the private people, will have not the authority to get something enforced. And therefore, for enforceability, I have to really go back to the court, which has the power and the wherewithal of executing a particular decree. So if I'm going to court and court is getting it executed, that does not mean that the entire process of arbitration is equivalent to a court thing, or because it was not a court thing, I will not get it enforced. And that is why the entire Arbitration Act has come into picture. So Arbitration Act gives that the legal framework which allows or which gives the authority to the individual private arbitral tribunals to cut short the process of court of law. So these two are different things. That doesn't matter that if I'm not going to a court of law, my arbitral awards cannot get enforced, because then the entire purpose of arbitration is that only.
So this is the last question for the day. in cases of international arbitration, which country's limitation act should be followed when it comes to the execution?
Parties decide. So for that, parties decide. So in any international arbitration, what the parties do is parties then decide upon a governing law. So whenever two parties, say I'm in India and there's a party in America and we are entering into an agreement, then we decide what will be the governing law for this contract. So we say the governing law is, say, English laws. So therefore, the Limitation Act, the otherwise the rules will follow as per the English law. And that's an interesting question. I'll give you a very, very interesting example for this. See, Indian law, when we say Indian law, suppose the governing law is Indian law before two parties, then what Indian law says that we have a contract and sometimes there are judicial precedents which are beyond contract. So if I have written that time is an essence of a contract in my contract, and then I behave in such a fashion that that I allow you extensions. Okay, so the Indian law says then you have yourself diluted your contract and time is no more the essence of the contract and you cannot claim on that basis. Okay. But if I have had English law as my governing law, English law says whatever contract you have agreed, even if your conduct has undone that, that doesn't matter. One conduct or two conducts, even if they are there, doesn't matter. You have to strictly go by your contract. And therefore, one of the parties can still say, because you have agreed to time as the essence of the contract, you have to complete a particular thing on time. And you have not done that, so you are liable for the damages. So therefore, the governing law is a very, very important governing law. So all the limitation, all the basic provisions of law, they govern by the governing law which the parties have agreed to. Right. Any other questions?
No, sir. Sir, I would like to announce one thing. After the end of this workshop, all the participants will be getting a quiz for which to receive your certificates, you will have to get at least 50% minimum. And if you get 95% and above in the quiz, then you will get a certificate of merit too. So everyone is requested to pay attention to the session and fill up the quiz accordingly. Yeah.
So wonderful. So I'll just conclude by giving one simple example of a Canadian arbitration, and then we'll conclude this session. So what happened is that we enter into an agreement. So Indian party, they enter into an agreement with the Canadian party. And the idea was that Indian party will supply certain goods to the Canadian party. Okay. The supply of goods were the tower parts. You know, electricity towers are there. So you have to supply these tower parts. So Indian party has to supply these tower parts to a Canadian party, where the Canadian party will install in making towers for the supply of electricity from point A to point B in Canada. So towers were supplied. So the specification for these tower parts were given by the Canadian party. Canadian party gave that, okay, these are the specifications, and the Indian party has to perform and to give the supply based on those specifications to the Canadian party. Indian party gave that, and the Canadian party installed those towers in Canada. But that particular point in year, the temperature in Canada went to minus 40 degrees with heavy winds. And therefore, these towers, they just fell off. Because at minus 40 degree temperature and this kind of heavy wind, the tower parts could not sustain, and they fell off. The Canadian party filed an arbitration against the Indian party, and the arbitration was going on in Canada, saying that you have given us faulty parts and you should pay me damages. The defense of Indian party was that I have given you parts based on the specifications you have given me, and therefore I am not at fault, because whatever specifications you have given me, I have given you the goods on that basis. Now, this was the question before the arbitral tribunal, which was constituted in Canada. It was an ad hoc arbitration. So one arbitrator appointed by the Canadian party, one arbitrator appointed by an Indian party, and then these two arbitrators appointed a third party in Canada, who was the retired Supreme Court judge of Alberta in Canada. Now, these three tribunals, they have to decide whether the Indian party has supplied the goods as per specification, and by supplying goods by specification, does that serve the purpose? Idea was, and the law was Canadian law. Okay, because initially the contract has come from the Canadian party to Indian party, so they have kept arbitration in Canada, ad hoc arbitration, and laws also of Canada. So they have kept every single thing in their favor. Now, the arbitration was going on, arbitration continued, and when it ended, the Canadian party said that you have not given me goods which are fit for purpose, and therefore I failed. Indian party said I have given you whatever as per your specifications, and therefore it is not my fault. Ultimately, the Canadian Arbitral Tribunal decided that, and as per Canadian law, and that is how it is, that as per Canadian law, if I have given you a specification under the Sale of Goods Act, other parties' duties are discharged if that party gives you the material as per those specifications. So if I have given you a technical specification A, B, C, and your goods fulfill all these three technical specifications, your liability is discharged. Had it been Indian law or English law instead of Canadian law for that particular arbitration, Indian law says they consider fit for purpose. Not only have to give you a particular thing which is as per specification, but it has to fit for purpose if the purpose has been told to me. As per the Indian Sale of Goods Act, there are multiple cases, kitten of cases in Indian law, that not only the specification should be matching. Suppose if you come to a chemist shop and you ask for paracetamol, and if I'm giving you a good, it should not only be paracetamol, but whatever purpose you have told me, it has to be fit for that purpose also. If it's completely not fitting for that purpose, even if it may be of specification, it may not be helpful for you. Because if I'm giving you a goods and that goods are not worthy in minus 40-degree temperature, which you have already told me it will be for these purposes, then I may be supplying you faulty material. But then again, because it was an arbitration in Canada, and as per the Canadian law, and Canada has various provinces, it was Alberta province law. So as per the Alberta Sale of Goods Act, the liability is discharged the moment you specify, you give the goods as per the specification, and therefore the Indian party won the case there. So this is also, you have to be very, very cautious when you are advising your client that what laws you are keeping, what kind of governing law you are keeping, because they all have a bearing. So one is an Algeria example whereby you cannot arbitrate against a government entity. One is a Canadian example whereby the Canadian law says if you are given as per specification, the goods are fit and fine and your duty is discharged. So you have to be really mindful when you are doing all these things. So wonderful. If there are any questions, we'll take on the questions. Otherwise, we'll just end this session here. This is an absolute pleasure to be with you all.
Thank you, sir. Please, there is one career-oriented question. Can you throw some light on the career opportunities in arbitration?
So I will ask Arjun first of all to share his opportunity, and I'll share my views.
Yes, we would like both the speakers to give
Sure.
their opinions.
What was the question?
Career aspirations.
For the career opportunities for in the field of arbitration. Okay, so there are quite a few opportunities in the field of arbitration. It could all start from so there's private practice, and then there's getting engaged in a private sector opportunity. So the first is that you could get into a law firm that does arbitration related work, and there are quite a lot of law firms that do that nowadays. So that is number one. So you could decide to start with a tier 1 law firm, tier 2 law firm, tier 3 law firms. There are a lot of them who do arbitration nowadays. So that's number one. Number two, you could also start with a senior counsel or with counsels who do arbitration related work, and get engaged with them on that basis. So you could also be able to be a junior with someone who does arbitration related work. So that's number two. Number three, you could also be involved with PSUs. So for example, there are quite a lot of public sector undertakings that have commercial law contracts, and those contracts provide for an arbitration clause, and whenever the dispute arises, they would need people with experience and expertise in the field of arbitration. So PSUs are the third option that you would have. The fourth option is also getting engaged in private sector, like in-house counsels. Again, there are all contracts that parties enter into have an arbitration clause nowadays, and therefore they also need people with experience and expertise in the field of arbitration. So that's number 3. 4. Then you have departments as well, when government departments. So for example, Ministry of External Affairs have positions with legal consultants, and those legal consultants provide for they are required to have experience in the field of arbitration, because whenever there are disputes that are raised against the government of India, they would need assistance from such people. So again, there are government departments that provide for opportunities in the field of arbitration. Then you could go outside India and do your LLM, for example, in the beginning in the field of international dispute resolution. There are quite a few good number of institutions outside that provide this masters and qualifications. And once you have graduated from such a university, then you have the option to either do a PhD or engage yourself as a research assistant to those professors in the field of arbitration. So that's number 1 career opportunity outside India. Apart from that, you could also start with foreign law firms. by way of vacation schemes, training contracts, or if you get a direct contract, you could also be engaged on that basis. Apart from that, you have these institutions like ICC, SEAC, MCIA. They are also in their secretariat looking for people in the field of arbitration, where you will be engaged by these institutions to cater to and handle the disputes that come to them. So yeah, there are quite a lot of options right now if you want to pursue your career in the field of arbitration. I hand it over to Mukul sir if he has anything else to add.
So there are very many career options, and Arjun has really explained it pretty well. So you have law firms where you can go and make your career. You have various institutions like SEAC and all that where you make a good career in arbitrations. Otherwise, individual counsels are there. But other than this, there's one more interesting area. If you are really good in international arbitration and you have some exposure, so suppose you have some 2-3 years of experience either in a law firm or with institutions like SEAC, etc., then all these multilateral funding agencies like World Bank and ADBs and AFDB, African Development Bank, Asian Development Bank, and other multilateral institutions like the various like International Monetary Fund, they also at times for certain projects of theirs require specialist people who are adept in international arbitrations, especially institutional arbitrations. They also keep on coming with vacancies because at times they also have this kind of what you call suits. And likewise, there's a very interesting area called the bilateral investment treaties, whereby international arbitrations are taking place between the sovereigns, and there may be certain specific governmental what you call arbitrations which may be there, and they can come out with vacancies. So there are quite a few of options. So you can be an independent lawyer in India, you can be a part of law firm in India or abroad, or you can be part of any of these institutional arbitrations or these multilateral funding agencies and their arbitration centers you can be part of actually, or you can be a professor in alternate dispute resolution. In fact, lots and lot of people are right now also making a good career out of mediation and conciliation. So which area is always taken as a second fiddle in the entire arbitration scheme, but then even that area is a very interesting area, and there are a lot of professionals who are making very good career out of just being a mediator or a conciliator, and that is just solving out the dispute. So what you are saying is you are saving a lot of cost for a company for it to go in arbitration. So suppose I have an arbitration clause and I can go and get an arbitration against the Arjun, but there's a mediator, there's a person X who is going and analyzing my pros and cons and the strength of the case and telling me that, okay, if you go, you will only get this much, and telling Arjun that if you go, you will suffer this, and trying to bring us and trying to solve our dispute through a conciliation. So in that also is a very good career opportunity, and for that we have to have a good experience of arbitration per se. So these are the various career opportunities which are there.
Okay, sir. So we can move to the vote of thanks. So with this remark, we end the day of our bootcamp day 1. Thank you so much, sir, for giving such a crystal clear idea about these topics and clearing all the doubts of our participants. On behalf of ADR Cell, School of Law, Manipal University, Jaipur, we wholeheartedly thank you for taking out some time out of your busy schedule and to share your knowledge and experience with us. And we are grateful to have you, Mr. Mukul Shastri sir and Arjun Doshi sir. And last but not the least, we thank all the attendees of this workshop for your patience and enthusiasm. We hope this session has been fruitful for all of you. Thank you for joining us today. Stay safe and see you in the next session. Thank you, sir.
Thank you.
Thank you so much. Thank you.
Thank you, Mukul sir. Thank you so much.